Hello and welcome to Monday Bagel, the podcast where we explore the evolving relationship between law, technology, and society. My name is Michał Jackowski, and today I'm truly honored to be joined by Professor Pascal Pichonnaz. Pascal is ordinary professor at the Faculty of Law of the University of Fribourg in Switzerland, where he specializes in contract law, Roman law, European consumer law, and comparative law. He's currently involved in multiple research projects, speaks regularly at international conferences, and is leading a new, very interesting project at the European Law Institute on algorithmic contracting. Today we'll talk about two pressing issues in the AI and law space: the idea of predictive justice and the implications of using AI in judicial systems, and algorithmic contracting, especially through the lens of European legal developments. Pascal, it's great you could join me here.
Thank you for having me.
Predictive justice is often presented as a tool to ensure greater consistency in court decisions. And we know that consistency is a pillar of public trust in the judiciary and element of the rule of law. In today's worlds of dynamic technologies, does this understanding of trust and rule of law shift? How would you define predictive justice in this context? And what does it aim to achieve?
Yes, thank you very much. I think indeed, first of all, to come back to your idea of consistency, I think it's dependent of two factors, right? One is the quality of the neural network, the algorithm that is running, and the other one is the quality of the data set that trained that algorithm. And so, of course, if you have biases in the data set, you will also be partly reproducing these biases or even amplify them, which means that you might have consistency or even greater consistency, but it doesn't mean that you will have accuracy to the result. And that's one of the main problems of predictive justice. What is predictive justice? The idea is that you run an algorithm that will propose to the user solutions, outputs that could even look like judgments, but in fact, these are just a result of an algorithm that predicts the next word and a sequence of words based, of course, as I said, of the database. And based on that, one would say, okay, you predict the outcome of a given case, of inputs you put into the algorithm, and that would give you an output. And of course, it's very tempting to leapfrog and to consider that this output is equal to a decision, to a judgment. And so the question is really, and maybe that's what we will discuss today, is really, does it equal to a decision? What are the risks, but what are potentially also some advantages?
Okay, it's really important because we are not talking only about prediction in technical sense, but somehow about legitimacy of the outcomes, trust in institutional logic. So, what kind of support do you believe AI should provide to judicial decision making? Where is the line? What are the limitations? We are both constitutionalists somehow. So what are constitutional, ethical, practical limitations? Where is the line we shouldn't cross? I have my own ideas, but I wonder what your are.
Well, first of all, of course, these AI tools are tools that might help you to find things that you know already, but you have difficulties to find. So it's a good way of conducting research to find information you have at hand somewhere. But if you are looking for something you don't know and you cannot verify, then of course it's very dangerous because you have an output that looks very good, that reads well, but you don't know whether it's true or not. Again, an AI will not give you true or wrong answers. That's not the purpose of large language models or generative AI, but it's really more about bringing together some statistical and most probable outcome, but what is most probable is not necessarily accurate. Given these aspects, I think that one potential use in the justice system of AI is, for instance, summarizing large bodies of text. If you receive a 200 pages submission by an attorney, the judge might use AI to have rapidly a good understanding of the context, and I think that's something the AI is good at. summaries, or maybe also writing some presentations, providing ideas, potential ways of arguments. But of course, you always need to be able to reflect on that and to be sure that this is something correct. And of course, also administrative tasks like fixing deadlines, dates, and all this AI would be good at. But certainly going on a more legal perspective, legal research, for instance, as I said before, it might be very tricky because you need, in fact, to redo the job yourself to extent, because you might have a probable answer, but especially with numbers might be completely bogus. Hallucinated, as one would say, because the AI will just say, okay, the number 2 or 5 is most probable, but it doesn't mean that this is the correct number, right? Because it's not about accuracy.
So you think that first draft given by AI is something we should avoid? We shouldn't let judges draft by AI?
Well, it's very tempting, of course, because one would say, when I read the draft, I can immediately see whether it's correct or not. The problem I see is a so-called anchoring effect, so that you get an output and that will have an impact on how you will look at the facts when you go through the file, because you have already a preset understanding of what the result might be. And the temptation is that you say, okay, there's so many decisions at hand for the AI that it might be often not bad or even good, but you're not sure it's the right solution in this concrete case. However, you have had a first anchor in your understanding. And I would make a big difference between a clerk. I come from Switzerland, as you said. We have clerks at the Supreme Court, and of course our Supreme Court judges work with these clerks. They might prepare a decision, and the judge will look at it, might correct it, and say, okay, I'm fine. So you could say, but AI first draft might be similar to a clerk's proposal. The difference, of course, is in the first place, with a clerk, you have an analysis based on reasoning of causal aspect, based of experience. With the AI, it's purely statistical, and it's purely about language and words that are following each other. And so you have something that looks like an output that could be prepared by a clerk, but the way it has been processed is totally different. So you cannot say whether that follows your own understanding. Now I see in your eyes you're thinking, yeah, but basically if you have a text that is based on legal reasoning, then implicitly you have potentially this legal reasoning reproduced by this statistical outcome. Yeah, and that's why it's tempting to take that as a first draft, because you read something that really could look like a human reasoning. Now, lawyers, we know that sometimes one needs to take more time to read the case to realize, well, this case looked initially as a standard case, but finally it's very different. And our quest for justice and equity would force us to go deeper in the analysis, right? And maybe that's what AI will not do, because it's based on the most probable outcome. But what is most probable is not necessarily what fits to the specific facts.
I'm laughing a bit because I was at the ECHR conference, International Conference of AI and Law, and there was a strong discussion if there is deep reasoning really involved or it is just statistical tool. So this is one thing, but I was participating in a panel where there was a presentation about Brazilian approach in judicial system by judges, and it appears that because of lack of policy how to implement AI, over 70% of judges draft their decisions with the use of AI. So it's a bad example of how lack of any policy affects somehow the judicial system in a way we wouldn't accept in Europe. But are there any jurisdictions that you know where AI has been introduced into the judicial system? Bad and good examples as well.
Yes, thank you. As you know, I'm the president of the European Law Institute, and this institute has a lot to do with AI, with governance of digitalization. And one of my vice presidents is Sir Geoffrey Voss, the Master of the Rolls and head of the judiciary in England and Wales, of the private law judiciary in England and Wales. And he recently introduced the right to use AI for his judges, but he did so by having, of course, a clear documentation of what it is, how to use it, where not to use it because it's dangerous. And this is done in a kind of test phase in order to see what is feasible, what is too dangerous, and also to bring the judges using it, because of course we will be living in a couple of years from now, probably in some countries, as you said already, with so-called augmented judges that will use AI in a way or another, but the difficulty is to use it correctly and to avoid being trapped by AI. So I would say the UK, England and Wales here is certainly a good example. Another example is China. So far as I know, in the Wuhan province, appellate courts have been allowed to use an AI system called Zhao 3.0. Maybe it's now we might be at 4, I don't know, which prepares decisions based on the fact that it has been given. And then, of course, judges receive a decision and they have the choice to decide to write their own decision. But of course, in a system where you have social scoring, where you have close supervision of what the judges do, there's a risk for judges to say, I do not accept the output of the AI provided by the Supreme Court of the Chinese people. And therefore, the tendency will probably be to follow what has been provided without knowing, in fact, how the AI system has been trained and also, what is the data set for that. So that would, to my understanding, at least what I know about what has been implemented, would not be the perfect element. And I was speaking to a Supreme Court president in Europe saying, oh, we are not using AI to prepare decisions, but we are using AI to anonymize decisions that will be published. And he just said, that functions quite well, but 2 points. One, of course, the AI could not be a public AI because, of course, then it would mean that all the data you put into this public AI would then be known and become public. And second, you need to have a system that works well, but you have to check. And he said recently they had a bad experience with one very tricky case where involving young people, and the person in charge of checking what the AI does did not see that some places the anonymization was not perfect. And I was just wondering why. It is not that that person didn't care about that. But if you have to do that day after day and you realize that it works quite well, of course, your attention is not as good. And that's the difficulty, of course. Because when you should really see something, you might not see it because you cannot concentrate all the time with the same level because, all the time it seems quite good. But this is certainly a good use of AI, anonymization of decisions. That's probably quite good.
Yeah, I fully agree. The Chinese example scares us probably most. And in Europe, I don't think we would agree to have judges accepting case by case prepared by AI. But do you think we would be willing to accept certain limits for sake of improving efficiency? For instance, right to appeal and proper 2 instances afterwards adjudicated by human?
So I'm using my smartphone to do calculation, multiplication I could do with my head, or cosinus, sinus, whatever. Now I use, of course, my computer to do that, right? But I should be able to do it by hand, but it's so easy and so quick that I trust the result. And maybe it's wrong, I don't know, but I do it like that. I think that people will use AI all the time because it's not so expensive and you get a first result. And of course, then They might negotiate with the other part. They might not even go to a judge, because they will have very quickly an answer that might look quite well, and might at least be a good starting point for their negotiation, not knowing maybe that they can ask more. So that's the first step. So I would think that a number of cases might not have gone to the court anyway because of the amount at stake. It would not be useful to go to court for such a small amount. And there, AI would certainly help to at least get a sense of what might be just and correct. Now, whether judges would use that, or we will have a system where we would say, small claims will be dealt with only with AI in the first place, I think we will get to that, certainly. The question is, as you say, do we then say there's a right to have a human decision on appeal if you are not satisfied? Now, the tricky point is, how do you know whether the output is correct or not, is accurate, right? So you might say, okay, I got this money, I'm happy. Then fine, because at the end of the day, what we want as lawyers is also peace in society. But if you do, suppose now we have an appeal, will we say to the judge, to the this person, natural person, you are not allowed to use AI? So in the first instance, AI was possible, but you as judge, as personal judge, you are not allowed to use AI. Will the people trust that judge? Because there's this idea that technology is good. You have all these decisions that have been taken into account by AI. People might just think that the AI decision might be more trustful than the judge decision. Think about a decision in attribution of the guardianship over children in a divorce case, for instance. Will the people say, oh, no, I want a judge to decide? Or might they not say, this is a man or this is a woman judge, she or he might be biased, and they might, maybe wrongly, but have the impression that the AI is not biased. Of course, it will be biased in a similar way, because the data set that was used to train that AI might have been also biased to some extent. Mm-hmm. And so, of course, the AI might also be biased, but people, because it's technology, might really think that this is not biased. So we see that there is a tension here, efficiency on the one hand, but above all, trust in technology. At the same time, of course, we know that this technology is not perfect, but will people really trust judges in the future in the same way they do today? Frankly, I don't know. We will see. But when we see what happens with our smartphones, I have some fear about that.
We trust them entirely, I think, or majority of us. As a professor of law, what do you think? Is it a trade-off between some constitutional human rights, fundamental rights, or not? Is it a normal flow of technology development?
Well, as professor of law, I think it's a real issue, and in particular, the issue of the right to be heard and the right to have a reasoned decision. When we say Article 6 of the European Convention of Human Rights, right? When we say I should have a reasoned decision, we are not saying I should have a decision with an explanation that is produced by the occurrence of words and of probability of occurrence of words. We think about something that should be rationally presented. Of course, nowadays one would be able to get such an appearance of rational argumentation as a decision. I mentioned the Chinese situation before, but the problem is that's produced by the AI, but that's not what was at the origin of the decision of the output of the AI. So you have in fact two outputs. One is the decision, one is the presentation of how these arguments could look like, but the two are not connected, or not totally at least. It's not what is being presented that was at the origin of the output. So we have a real problem of Article 6, European Convention for Human Rights. in a way, using a well-known term, I would say we have a kind of fake explanation, because this explanation is not based on rationality, is in a way at least disconnected from the output. So I think this is a real issue, and we will need to think and discuss whether we will no more care about Article 6 in the sense that we understand it now, and say, okay, if you get some sense of, potential argumentation, even if that argumentation is not the one that produced the outcome, it's okay. I don't think it's okay for me, but that's really something we will have to discuss. A second aspect is also the data set itself. This data set has culture embedded in the data set, because of course, if you have data set coming from, let's say, mostly English-speaking countries, common law countries, then the probability of occurrence of words, and therefore of appearance of argumentation, will be more common law-like, if I may say so, or American law, or culturally linked to American law-like. And therefore, the question is also, will we be influenced? With that, change our understanding of the law, because we get outputs that are culturally embedded in a different setting? I would say probably yes. And then the question is, will this law or these results produced by AI be still in line with our own culture, with the people that will receive these outputs? Or will our culture evolve because of that? Now, culture evolves, but the question is, does it evolve in the right direction? Is it a kind of globalization of outputs, of legal outputs? So I think this is also an aspect of, at least which concerns me, because I think we are not always aware that we will be culturally driven to a certain way without realizing it, just because of the use of these AI systems.
I would love to dig deeper into reinterpretation of Article 6 and maybe some dynamic change of the sense of the provision, but I would like to turn to algorithmic contracting. So this is the project driven by European Law Institute that recently adopted the output of the project on this topic. You lead the European Law Institute. So could you tell us about this project? What is it about? What's main objectives are?
Yes, of course. Thank you very much for that. So the idea is to decide what to do if you have two contracting parties and maybe one or both of them are using an algorithm to conclude the contract. And of course, this is not just fantasy. On stock market exchange, you have a lot of buying and selling of shares that might even be driven by AI systems in the background. But the European Law Institute wanted to check what would be the prerequisite of using AI to conclude consumer contracts. We have a whole set in Europe of consumer law, protection of consumers, and therefore the question was, if you use an algorithm to conclude a contract, are you in danger of losing your protection as a consumer and consumer law? And so we ended up with a series of 25 articles, principles, trying to help legislators and also judges to analyze the situation. And the most likely example is what we call the smart fridge. You buy a fridge that is able, after being trained for a couple of months, to understand that on Tuesdays you're drinking beer because usually you have friends coming, so you should be sure that enough beer is in your fridge, or you have a lot of eggs, or you have someone in your family with this and that, and it will adapt also according to the weather outside. One knows that if it's warm outside, you drink more beer than if it's cold, and whatever, And so this is probably a little bit of fantasy, but recently I was told that some people use AI to conclude electricity contracts, and the AI will decide when to terminate a contract, when to pass a new contract with a new electricity provider for the benefit of the end user. So that's a reality as well. So you have in fact two contracts. One is the supplier contract. So I buy my fridge, right? And I need to know what I'm buying. So I'm not just buying a fridge, I buy also the AI system. And therefore I need to be informed about the parameters, about whether or not I can change that, to what effect, and so on and so forth. And there I need, for instance, to be able to deactivate this, what we call digital assistant, this AI, because maybe I don't want to continue to conclude contracts, or, I go for holidays for 2 months. So I need to be sure that my AI assistant is not continuing to buy, milk and whatever while I'm away. And of course, there are issues of liability and so on. But the main aspect is the second contract, this algorithmic contract, as we call it. So my smart agent, my AI assistant, is concluding a contract with a supplier of food, for instance. Now, first of all, is the contract valid? Because in fact, there was no one on my side saying, okay, we conclude that contract. We decided, yes, it should be valid, because basically I accepted to conclude with such algorithm. And therefore, I take the risk in a way as consumer to conclude this contract. And secondly, of course, how will this contract be concluded? Well, there are different models. I could say, I don't care. The AI is doing its job, so to say. But I begin to care if the amount is superior of 100 or 200 euros, because then suddenly there's a lot at stake. So I want to be sure either to oppose to the proposed conclusion of the contract, or at least to object, or to consent. And I would, for instance, get a push on my smartphone about you have 2 hours to oppose to the buying of a couple of bottles of milk, for instance. So that's also what we provided for in one of the articles. Then we had something about, disclosing. Should I disclose that I'm using an AI to conclude the contract? We think we should. This is important, but maybe in the future people will be so used to that it would not matter. And one thing is really important is the attribution of the conclusion of the contract to the user, right? The consumer is using this AI. As I said, the contract is valid even if there's no intention of the consumer to use it. And it means that it is as if the consumer would be the party concluding the contract. But are there some limits? And we thought, yes, there should be some limits, because if I find suddenly 10,000 bottles of milk in front of my door, I would say, come on, that's not what I was expecting. The outcome is really not objectively reasonable. And so probably the supplier of these bottles of milk should have thought about it, should have realized, there might be a problem, or at least checked. And there we think that the risk should not be borne by the consumer itself, because it goes outside of what could be objectively and reasonably expected. Now here, of course, to draw the limit is not easy, and we gave a number of factors in order to understand what is objectively reasonable expectation. But I think we will certainly set a quite high limit of reasonableness, in the sense that one cannot say I'm using an AI and each time it's not totally in accordance with what I was expected, I can reject the result, because as we said before, AI is functioning on a probable outcome, and you take some risk by using that. But so we really went into a lot of details, also with commentaries, and I think that the result is really impressive, because we have some innovative elements also on the design, how to design these AI so that they work well. And as you said, the project has been now adopted by all ELI members, by the council, and has already influenced some of the evolution and adoption of other models that have been approved by Untitled, for instance, by the UN. And the EU will probably also go into that, and we will see what will happen.
This was my last question. What do we need to implement this example, this system, this algorithmic contracting, and to align with fundamental rights in the EU?
Yes, exactly. That's a good question. And we try to take into account fundamental rights in these principles. Also the principle of autonomy. So you could decide, whether the contract is concluded without you having any knowledge about it, or on the contrary, you want to say each time, I accept or I object. So fundamental principle, fundamental right of autonomy is central. And to implement that, I would probably think that it depends of the producers of these Internet of Things, whether they think that their risk is not too high. And I think innovation will go forward because if we have something like what has been proposed by the European Law Institute, it is well balanced, and therefore, it will sustain innovation. It will make a business interested in concluding with AI assistant. But of course, at the end of the day, it will also depend on the quality of the AI produced, and whether people trust in this type of conclusion of contracts. My impression is that because we are so much surrounded by AI, by digitalization, that our trust in these devices that are always better, coming better and better, will increase. And therefore, I think things will go pretty soon into motion in this respect as well.
Pascal, thank you so much for this insightful and deeply grounded discussion. I have recently conducted a research on the use of AI by lawyers, and there is a great gap of knowledge how to use AI properly. Lawyers do not know, except for some general ideas about document summarization or generation, they don't know the use cases how to use AI. So both predictive justice and algorithmic contracting are great examples how to use AI properly, trustworthy. So it was a great discussion.
Thank you very much. And indeed, for your auditors who are interested in the concrete articles, for instance, on the algorithmic contracting, you can find them on our website, so europeanlawinstitute.eu, and there you will find all the materials you would look for, including some interesting webinars to go deeper into your reflections.
Of course, I will link them under the episode. So thank you once again for joining me, for being here, for speaking to the audience. And for our audience, if you enjoyed this conversation, be sure to subscribe to my channel, to subscribe to Monday Bagel, explore our other episodes, and join the discussion about how technology is reshaping the legal world. Until next time, thank you for listening.
Thank you.